just can't wait. They are all so good. Hey, Brandon, are you about ready to get started?
Ready when you are.
Invitation, are you just crashing the party here?
Yeah, apparently.
Oh, I looked up an IRA. It's Irish Republican Army. What does that have to do with estate planning?
I don't know. There's another definition for IRA that's individual retirement account. I think that's probably more what we're going to be talking about besides the Irish today.
Oh, would I qualify to get an individual retirement account for all the work I do here at this slave shop law firm?
I don't see why not. Alan should
Sure.
definitely be contributing some to the pension plan for you, I believe.
Okay, could you apply for a tax ID number for me?
Sure.
Super. All right. Well, Alan is on his way here. I hear his big, clumsy footsteps. And I heard what you said about him yesterday, and I agree completely. Everybody, here you go. If you have other things to do today, you may want to do them instead of watching this, because it's not going to be very practical or very interesting. Oh, here he is.
Or have a nice Irish coffee while you're listening to this.
Irish coffee. That's a great idea. That's what this should be, an Irish coffee. I'll have to put some scotch in it.
There you go.
Okay. Well, welcome to Saturday, July 2nd. The rest of your life just started. This is the real life. It's not a dress rehearsal. We'll take it seriously. And we're going to talk today about a concept that sometimes is addressed in way too complicated terms. So we want to make sure that we cover the practical terms, and the whole set of rules for IRAs and pension accounts as they go into estates and trusts are in a state of flux because of what was called the Secure Act, S-E-C-U-R-E. I don't remember what that stands for, but it does not. It provides job security for lawyers, is what it does. And we're not going to talk as much about the Secure Act today as we're going to talk about how to secure your pension and IRA account in estate and trust planning. So, first of all, Brandon, as the dummy said, what is an IRA? What is a pension account?
Yeah, so these are accounts that get special tax treatment from the IRS. There's limits on what you can contribute into these accounts. There's requirements of what you have to take out of these accounts once you get to a certain age. There's also requirements of what has to come out of the accounts upon death. And there's different rules depending on who you leave the account to, whether that's to a trust, who are the beneficiaries of the trust matter, who are remainder beneficiaries of the trust matter for purposes of applying, what payout rules will apply. There's also tax deferral available for these accounts. When you put money in, they grow tax free, but when they come out, they all are subject to ordinary income tax. So that's a little bit of the planning we're going to talk about, is maybe how you spread out that income tax to beneficiaries that might be in a lower tax bracket, and what you can do with trusts to kind of facilitate that. So there's a lot of interesting stuff you can do, a lot of tips and tricks we're going to talk about as we go through the slides here.
Okay, so for those of you who are not lawyers and CPAs, the IRA and pension account rules are very highly regulated. And one reason is that Congress feels like, hey, you got a nice income tax deduction for putting this money away. It's for your retirement. It partly belongs to the government because when you finally take it out, you're going to pay the taxes on the money then. And we don't want it abused, and we don't want you to be able to abuse it. So the real owner of the assets in your IRA and in your retirement account are not you. The real owner is the custodian of the IRA, who has to follow hundreds and hundreds of pages of rules to comply, or the trustee of a pension plan, who has to cover hundreds of rules in order to comply. So, for example, I cannot transfer my IRA to anyone. It is stuck in my name. I could withdraw from it and pay the tax, but if I wanted to transfer my IRA to my children while I'm alive, I can't do it. The only way you can actually transfer an IRA would be to get divorced. And that, you just tell your spouse, hey, I really wanted to transfer my IRA. The only way I can is to get divorced. So we need to get divorced for that reason mostly. But then the only person you can give your IRA to is the person that you're divorcing in what's called a quadro. And a quadro is also very complicated. And pension plans work the same way. The thing I want to mention before we get into the materials is you can't do things with an IRA or pension that you can do with your own money. For example, when I first started practicing law, one of my first clients had 6 Jaguars in his pension plan. And I went to the CPA and I said, why does he have 6 Jaguars in his pension plan? And the CPA said, well, the pension plan bought a car dealership and it didn't do well, so we liquidated it to get the losses. So we had, and I said, wait a minute, IRAs can't take losses. And he goes, oh yeah. So you see, he wasn't a very good accountant. But I told the client, I hope you have never driven any of those Jaguars. And the client said, I will take the Fifth Amendment on that. So his whole pension plan could have been disqualified. The other thing we see a lot of is people go to courses on how to invest your IRA. And they go, oh yeah, you could just invest your IRA in rental homes and just get one of these IRA custodians and just invest your IRA in rental homes. And you can go in there and fix up the home. No, you can't. You can't step a foot in that home. If you put one brush of a paintbrush on that home, then you've disqualified the IRA. So we want to be very careful with these rules. Now, before we get started and I tell you anything that gives you any information you can use at all, please remember that this particular presentation does not qualify for continuing education credits. If you want to ask a question, you go to the questions panel, you click on the inverted pyramid, and then you type in your question, and we will do our best to answer it. And we have other presentations coming. We are doing a series for the Kettering Health Foundation in Ohio, a very worthy chain of not-for-profit hospitals. And you can sign up for one of these presentations. And then Saturday, July 9th, I'll be doing Fun and Dick with Dick and Jane, the very basics of estate planning. And July 13 for the Florida Bar, part 2 of Hot Topics and Best Strategies for Estate Planning. So enough shameful self-promotion or shameless self-promotion. Brandon, how is the book coming? The rewrite of our book on IRA and pension planning.
Yeah, so we're about halfway through with an update for the Secure Act and the proposed regulations under the Secure Act. So I would expect maybe in the next week or so, we'll have an updated version of this available that will incorporate all the proposed regulations under the Secure Act. It's now currently up to date for the Secure Act that came out in 2020, and then just needs an update for the proposed regulations, which didn't change a whole lot. We'll get into what they did change, and for the most part, they were good changes, taxpayer friendly, with the exception of kind of one rule that we'll get into related to what happens in the 10 years after the death of the IRA owner. But other than that, mostly favorable changes. So that should all be good news when you get the updated version of the book.
So those of you who are interested, I've been through the entire book and I've made all the changes that I thought we needed. Now Brandon's going to go through it and make the changes that I missed, apparently. If you want to be a beta reader and get our redlined draft version, just let us know in the question panel or send us an email. And the only thing you have to promise us that you'll look at least 20 pages and give us your markups and ideas. Has nothing to do with a beta fish, though. If you want a beta fish, then that's a whole different situation. All right, so Brandon, we decided we wanted to start towards the end, right?
Yeah.
And then people who daydreamed off, we could just tell them we're almost done. Do you want to start with the charitable remainder trust?
Yeah, I think this is a good place to start. Just a little bit of background while we're talking about the charitable remainder trust is the Secure Act did make one kind of unique change to the IRA rules, in that historically, after the death of the IRA owner, distributions had to come out, those required minimum distributions, over the life expectancy of a designated beneficiary. That can still apply, but it only applies when there's certain individuals that benefit from the IRA. Your surviving spouse, someone that's not more than 10 years younger than you, a disabled or chronically ill beneficiary, or a minor. Those individuals can still get that lifetime payout. But if you're not one of those individuals, you're just an adult child that's a beneficiary of the IRA, then all of the assets in the IRA have to be distributed within 10 years after the death of the IRA owner. So a lot of planners are now saying, well, what can we do to almost mimic that old life expectancy payout? Because, I don't really trust my children to receive, this lump sum IRA in 10 years after my death. Is there a way I can control it and sprinkle it out a little bit over time? And the charitable remainder trust can do that. So we have an example here just to talk about the differences. We have $1 million IRA, taxpayers in the highest bracket. We assumed a 7% rate of return. And how does this work? So, here's the 10-year rule. Here's what happened if you just left your IRA to the adult child. It can sit in the IRA and cook for 10 years if they died before they started taking required minimum distributions. The proposed regulations did change this 10-year rule slightly, and this is the unfavorable change the proposed regs made that I talked about, that if the IRA owner died after they started taking required minimum distributions, so they died after the age of 72, then the only difference here is in years 1 through 9, there would be distributions having to come out of the IRA. Now, it doesn't make a whole lot of difference in the numbers, but that's just one minor change. If you died before the age of 72, then you can defer the full 10 years. If you died after the age of 72, then you have to take out 3 or 4% each year in 1 through 9, and then everything comes out in year 10. So we let the IRA cook for the 10 full years in this example. The taxes are paid when the distribution is made from the IRA. The net amount left to the beneficiary is here around $1.2 million. And we just assumed it was reinvested. Now it could be spent, it could be lost. This is a good beneficiary and assume that they're not touching it, they're just going to let it cook. Now, how does that look if we put it under charitable remainder trust? So a charitable remainder trust is essentially a trust vehicle that says, I'm going to pay out a specified percentage each year annually to a non-charitable beneficiary, so to your child, for example. And then after the end of the term, whatever is left in the charitable remainder trust goes to a charity of your choice. And what that can do is we can set this charitable remainder trust to pay out over the life expectancy of a beneficiary. So it could be a lifetime payout. It could pay out over a term of years. So like in this scenario, we said it's paid out in 20 years, and at the end of 20 years, whatever's left goes to charity. And so how does this work compared to just the 10-year rule? Well, we put the initial balance into the charitable remainder trust. There's no taxes paid because it's paid to the charitable trust, which is a tax exempt, almost like an IRA type vehicle. The assets grow at the same rate. Around 10% of the assets are required to come out to that non-charitable individual, so to your child, for example. Taxes are paid as that comes out. It retains the same tax character, so it's still ordinary income when it comes out. And then again, like before, we assume that whatever came out after taxes would just be reinvested. So this was a 20-year term. The beneficiary after 20 years would have around $1.9 million. Around $450,000 would go to a charity. So you get a nice charitable benefit associated with this type of trust. This could be a private foundation that your child could manage and do operations with and do charitable activities. It could be, your favorite public charity. It could be the American Heart Association. It could be the local community foundation, the YMCA. Any of those can be beneficiaries of a charitable remainder trust. So when we look at the difference here, there's not a whole lot of difference between the 10-year rule and a charitable remainder trust. So if you're concerned about assets coming out as a lump sum in 10 years of $1 million or more, then this could be a nice vehicle to use to spread out those distributions over a period of years, over the life expectancy of a beneficiary, and almost mimic those old rules that applied historically with required minimum distributions. And actually, when we look at the combined amounts that go to a beneficiary and a charity, it's almost better than the 10-year rules. You see here, after 25 years, 3.1 has went to charity and your child, whereas under the 10-year rule, only 2.9 came out to the child. So this can be a good, useful tool for IRA planning.
Now, what this doesn't take into account is that for a lot of people, the tax rates will go down as they get older. So, typically mom and dad are dying at 85, son and daughter are 60. At 60, you're typically at the height of your earning, but then at 70, 75, you stop working. So it's perfect. Had we run the numbers where you don't take anything out of the NIMCRUT until year 10 and then take it out from years 11 through 20?
Yeah, that would be an interesting scenario. And we've always run this assuming that the highest tax bracket did apply. But it would be interesting to see if there was a drop in the rates. I would think the numbers would be more favorable for the charitable remainder trust, particularly if you're looking at someone with the 10-year rule being around 60, still in that higher tax bracket, where if we can defer it out using the charitable remainder trust 25, 30 years, they might be in that lower bracket at that time, which would, certainly allow for more to come out of the IRA and less to go to Uncle Sam.
So Brandon, could I set up my IRA to go to my wife, Marcia, and then if she doesn't survive me or she disclaims it, it would go to a trust for my daughter, and then if the trustee of that trust disclaims it, it would go to the charitable remainder unit trust with a 20-year payout to a trust for my daughter. So then on my death, my daughter could basically ask the trustee, my daughter could take up to 9 months to decide whether she would like the trustee to take it out over 10 years just for her and her children, or take it out over 20 years for her and her children and a charity. That could my daughter also have the right to designate the charity?
Yeah, all that is permissible. The proposed regulations that did come out did confirm that if an individual disclaims, they're treated as having predeceased the IRA owner or whoever the beneficiary was, and just disregarded. So it's not going to impact the payout rules. It can flow through to your daughter to take as beneficiary under the trust. The trust could disclaim the interest and it passed to the charitable remainder trust under this 20-year payout or a life expectancy payout. The trustee of the charitable remainder trust would have the discretion to change the charitable beneficiary of the charitable remainder trust. So you have flexibility there as well if you want to retain that type of power to designate who the actual charitable beneficiary is at the end of the term.
Then again, with that disclaimer situation, it could still be a NIMCRUT where they could decide how much to take out each year to actually maximize the payout. Because when you use a net income makeup CRUT and you take a large payment in year 14 and then convert to a charitable remainder unit, a conventional charitable remainder unit trust at that time, you'll get out, charity will get less and you will get more by the law of arithmetic.
Yeah.
So, and is it time consuming or expensive for the estate planning lawyer to draft for this choice to occur, assuming that the estate planning lawyer has the forms to do it?
Yeah, no, it's not expensive at all. It's the charitable remainder trust itself is a relatively simple document, 10, 15 pages or so of provisions under there with some safe harbors and safety clauses that would apply to make sure the CRUT qualifies. But other than that, it's a relatively simple document. Doesn't take a lot of time. Doesn't require a whole lot of maintenance. There's basically an annual information return that has to be filed, the form 5227. But it's not complicated. It's not in depth. The assets should probably all be marketable securities, so there's no valuation issues. You can just look at your account statements to determine the value of the trust as far as paying out each year.
What I think a lot of clients will like also, and you don't, and all those things you said about an annual form, none of that gets filed until after the
Right.
person died.
Right.
But I like number 3. It forces the heirs to take the money out slower. That can be a very good thing. All right. So should we talk about the IRA versus the self-canceling installment note now?
Yeah, so this is another interesting scenario that came up with a client recently, and they were estate taxable, and the main problem we were dealing with is they had this large IRA of around $7.5 million, and what we were trying to determine here is, well, eventually this IRA is going to be taxed. So what if we just liquidated the IRA, paid the taxes now, and then that way we're able to do traditional estate planning with this IRA by placing it under the assets that would come out of the IRA, which would mostly be marketable securities, into an LLC, having non-voting interests sold to a trust for descendants in exchange for either a promissory note or a self-canceling installment note that would disappear basically at death and therefore not be included in the estate. And the results were surprising. You would think that paying the tax early, liquidating the IRA is a big no-no, and particularly when you try to tell a client that they're going to owe $3 to $4 million in taxes if they do this, most clients aren't interested in that. But I think it's something that should be explored, because when we ran the numbers, it turns out that we are actually better off, liquidating this IRA and doing the traditional estate planning and paying taxes early. So here, if you look at the numbers, we have our IRA assets growing. We assume that the death would occur in 10 years, at around age 87 for this particular client, which was about her life expectancy. The non-IRA assets are on the right-hand side, so you can see their growth. At the death, we satisfied the estate tax, which is around $6 million, because the estate taxable assets were around 15. So we decreased that $7 million account down to $1 million and let that cook for another 10 years just to see what the results would be. So at the end of all this, we had around $13 million left after the 20 years. So what did it look like if we liquidated that IRA and paid the tax? So the top left, you can see the liquidation here. We pay the taxes on liquidation. We put the net amount into a trust, put it in an LLC, sold non-voting interest in that LLC for a discount. We assumed a 25% discount, which might have been a little conservative, but we wanted to be on the conservative side for purposes of running these numbers. And that would give a $3.4 million approximately self-canceling installment note. So the client being a little bit older, there was a higher rate of interest on that note to account for the risk of the note holder passing away before the balloon payment at the end of the term. So it was around 8.5% interest. So you can see the interest payments being made here. The trust balance, which is outside of the estate, and then the combined balance of assets inside of the estate over here on the far right. So in this scenario, we only owed $3 million of estate taxes compared to previously around $6 million of estate taxes. But of course, her estate was smaller because she paid, some taxes early. So how did it look after the 20 years? Well, it turns out we were ahead by around $1 million versus doing no planning and just letting the IRA run for the lifetime without doing any type of early liquidation. So you can see here, and we can send you these spreadsheets if you want to run numbers on your own and then, plug different things in. But it is an interesting scenario as far as, what you could do with the IRA with some traditional kind of outside the box thinking of liquidating that thing early and then doing more traditional estate tax planning with the remaining assets.
Now, with this, why couldn't the skin have let us avoid estate tax completely?
Well, there was a Q-tip trust that was also in this scenario that we had to account for, which was what resulted in the majority of the estate taxes being owed there.
Okay. All right. And for those of you who are not tax lawyers or professionals, a Q-tip trust is a trust full of those Q-tips that you would get like at Walgreens or Publix. So she could always, she has a whole lifetime of being able to clean her ears out. She had millions and millions of dollars of Q-tips. Okay, so now we'll talk about the teapot trust. And the teapot trust was an idea that we came out with that we thought was a good idea, so we gave it a name. And the name has nothing to do with marijuana, by the way. Marijuana had nothing to do with the idea either. What we thought was that you are typically wanting to treat your children equally. So a typical estate plan is going to say, I am giving 1/3 of my estate to neurosurgeon, 1/3 of my estate to school teacher, and 1/3 of my estate to the surfer. And I'm going to split up my IRA of 900,000, 300,000 to each of them. And mathematically, that doesn't work well because the neurosurgeon is going to pay a 40% tax as she receives the money out for her share, the school teacher at 25%, and the self-supporting child at 10%. So it would make more sense to give the whole 900,000 IRA to the self-supporting child and give other assets to the neurosurgeon and the school teacher, but there's no way to get the exact right formula because no one knows what the right formula will be. And by the way, the neurosurgeon may retire in year 9, the school teacher may marry a plumber, and plumbers make more than neurosurgeons, we all know that. So how do you get the flexibility to decide what you're going to pay them, and how do you make it fair? Well, one idea that we had was, let's set the $900,000 aside into a trust that really can spray out to anyone. So some people call that a spray trust, some people call it a pot trust. And that sounded good because then over the 10-year period, you would just decide how much each child would get. But then if you spray it all to the surfer child, and by the way, I have nothing against surfers. Some of my best friends have fins. They're called lawyers. But anyway, how do you handle that? So we came up with the idea of a two trust system, knowing that we could charge more for it if it had two trusts and a neat name. And what happens is, on death, for this particular client, the $900,000 IRA is going to the teapot trust, and another $1.4 million is going to what we call the equalization trust. So now what happens is the 3 children have a reason to meet every year, and they meet with the trust advisors, and they talk about their tax brackets, and they talk about their needs, and they talk about whether to delay the distribution or take the distribution. And you know, they have until about 10 years after the client's death. And then if the whole IRA really should go to the surfer child mostly and to the school teacher a little bit, then the neurosurgeon can get money from the equalization trust. And then we thought through, you know, what are some of the advantages of this? Well, one, it kind of keeps the kids together. Number 2, it causes the kid who's the best influence, who has his or her act together the best, to kind of be a leader in those meetings. Number 3, it causes them to have a second bite. If they screw everything up in the first 10 years, they still have this coming. And then, you know, it gives the lawyer and the accountant an ability to kind of stay with the family and see what's going on, which we think is commonly a good idea. So when you run the numbers on this and you look at a typical tax savings arrangement, you can save a few $100,000 and have that flexibility. So that is the Teapot Trust. There's a video on it if you go to YouTube and search Gassman Teapot Trust. Kristen Sweeney juggles a teapot trust and a child. It's really cute. So that is the Teapot Trust. Has nothing to do with the Teapot Dome scandal. You can read about the Teapot Dome scandal. Believe it or not, there was a dishonest politician who got involved with a donor, and that's history. But the Teapot Trust is much better than that. So Brandon, what should we cover next?
Yeah, I think one thing to mention while we're in the practical planning area is, the idea of leaving assets outright to beneficiaries versus leaving them in trust. And, the trust does complicate things a little bit as far as planning after death goes, but it's not nearly as complicated as some people make it out to be. And, I think the important thing there is these assets, while they're in the IRA, are protected, but if you leave them outright and then everything comes out after 10 years, they become unprotected. They can be lost in divorce, they can be lost to creditors, they can be spent unwisely. Whereas if they come out of the IRA in 10 years and go into a trust, that trust can govern, what comes out of the trust. So even though it has to come out of the IRA, it can still go into a creditor protected vehicle, a divorce protected vehicle, have provisions so the trustee makes sure that the beneficiaries are spending the money wisely, not living off the trust. There's a lot of things practically you can do with that. And I think that's an important conversation to have with clients, important conversation to have with your advisors. If you're looking at IRA planning, especially if you have a large IRA, is what happens to this IRA after my death?
Right. So that's a good point, and I'll just mention what happens. A lot of times we draft revocable trusts and we provide for the IRA to be payable to the revocable trust, and then the revocable trust has the instructions on what to do with the IRA. And a lot of times the investment advisor wisely points out to the client, wait a minute, this may have to come out over 5 years instead of 10 years. But if you know how to draft the trust agreement, you can ensure that it would come out over the 10 years versus the 5 years. And we're going to get new regulations on this in, I hope, this year. And I think they're going to be fairly reasonable and allow us to have even more flexibility than we had before in order to have a trust qualify for a 10-year stretch. Although the lifetime stretch for anyone other than a surviving spouse or a disabled child or a chronically ill person or someone older than the IRA owner who died, those lifetime stretches are going to be gone. So Brandon, should we kind of talk a little bit about what the overall rules are here?
Yeah.
I'm feeling that most of our attendees don't want to know, well, before the Secure Act, well, after the Secure Act. I think they just want to know, what is it now?
Yeah.
So why don't we talk about the pyramid? And by the way, with a food pyramid, I don't believe that you need carbohydrates. So please do not consider our pyramid here an endorsement of the FDA food pyramid. And don't think that ketchup is a vegetable either.
I don't know. I might disagree with that one, Alan. I do love some good ketchup. But anyway, we came up with this pyramid system to really talk about and try to explain to clients, what's the most favorable payout and then what's the least favorable payout. So the most favorable payout, top of the pyramid, best scenario is you can leave your IRA outright to your surviving spouse, who can then roll over the IRA and make it their own. What that allows is, one, your life expectancy, just according to the IRS rules, is based upon two people, a spouse and the IRA owner. So you get a kind of a combined life expectancy, two people life expectancy. Those required minimum distributions get to be recalculated annually, meaning you go to the tables, you find your age and the associated percentage that has to come out of the IRA, you multiply that by the balance, and that's what comes out. If the spouse is not yet 72, they can delay the distributions until they are 72. So there's a lot of advantages to leaving the IRA outright to a surviving spouse. Now, what are the disadvantages of that? Because you want to think about practically as well as tax planning as well. It's the best for tax purposes, but the IRA can then, the surviving spouse can then change the beneficiary of the IRA. They can liquidate it and do whatever they want to do with it. So if you want that to be protected, then you might consider leaving it to a trust. And then we get down to level two. Level two would be a trust for a surviving spouse, an outright distribution to one of the eligible designated beneficiaries, which would be someone not more than 10 years younger, a disabled individual, or a chronically ill individual, or a trust for those individuals. And in that scenario, you have this life expectancy rule where you look at and this is the same rules that applied pre-Secure Act for those that are familiar with that, is you find who the designated beneficiary is, you look at their age and their life expectancy, and then you find that associated rate on the IRS tables, and then each year you decrease that age by 1. So if that's paid out over 25 years, 4% has to come out, 1 divided by 25, and then you go on down the list, 1 divided by 24, 1 divided by 23, 1 divided by 22, so on and so forth, until the IRA is liquidated out over the life expectancy of that individual. What's next is an outright distribution or a trust for a minor child. The minor child is an eligible designated beneficiary, but only while they're a minor. Once they reach that age of majority, which is 18, or actually it's now 21, it's 21 under the new proposed regulations, that it has to come out within 10 years. So by the time they're 31, the entire account balance has to be liquidated from the IRA. Level 4 is basically a trust or outright to any other individual. So your typical adult child would fall under this scenario. And in this scenario, everything has to come out of that IRA within 10 years. And that's why we came up with the teapot trust as well, because historically it mattered what the ages were of all these beneficiaries. If you had a 40-year-old, a 35-year-old, and a 30-year-old, the payouts would be different based upon their life expectancy. But now all 3 of those individuals have a 10-year rule. So that's why we're able to have some flexibility with having that pot trust and allowing more control of the distributions and spreading the income out across tax brackets, because the 10-year rule applies regardless of whether it's left to a trust for them, outright to them. It doesn't really matter what the ages are anymore. So in a way, this simplified things compared to the old rules. And then finally, the bottom level is the default rule. When you have no eligible designated beneficiary, everything has to come out within 5 years or based upon the life expectancy of the IRA owner. So whoever deceased and their life expectancy would apply in lieu of the beneficiary's life expectancy. So this was when you have a charity as a beneficiary, an estate as the beneficiary, or if you have a trust that's not properly drafted or you don't comply with certain requirements, then that's where this default no designated beneficiary rule would apply, which is the least favorable payout method.
Okay, a lot to digest, but going back, outright to spouse on death, spouse can roll over into his or her own IRA and then takes out very slowly compared to in trust for spouse's lifetime. Then it comes out into that trust much more quickly. If it goes into a trust for spouse and minor child, then it can come out more slowly, which is a better thing until that minor child is no longer a minor. So, wow, a lot to think about. By the way, one thing that we like to use that is not well publicized is, how about I leave my IRA to my spouse, but my spouse signs an agreement that says that my spouse agrees to invest it with a reputable investment advisor, not take out more than my spouse reasonably needs for health, education, and maintenance, and to make the beneficiary of that IRA a trust for my children. Brandon, do you think an agreement like that would hold up under state law?
You know, I think it's worth a shot. There's nothing out there that says it doesn't hold up under state law. I think it, you know, is something that could be incorporated into, you know, like a post-marital agreement or even the premarital agreement that, you know, I'm going to leave you my IRA, but considering that, I want to make sure that it goes to my children and it doesn't go to, you know, a subsequent spouse after my death, or, you know, the pool boy, or any of those individuals. So you want to try to plan as best you can for that. And, you know, it's better to have something signed than nothing signed, I believe.
I mean, I think the IRS could argue that it wasn't really an outright devise and it's a constructive trust. The chances of that the IRS finding that or succeeding in it seems pretty remote. You could see the surviving spouse and their next spouse going to court and trying to say, well, this is against public policy because it's a cheat on the tax rules. But I think at the end of the day, there's a good chance it would hold up. And as a practical matter, it gives a surviving spouse something that she can show her new spouse and say, sorry, but we have to follow these rules. And by the way, I really want to follow these rules. Now, another thing is the surviving spouse could just take a life annuity. And if you're under 55 and you need the money, then the surviving spouse rolls it into her own IRA and doesn't want to pay the 10% excise tax, so she just takes an annuity for life. Let me mention that IRAs can be invested usually in stocks and bonds and real estate investment trusts, sometimes in actual real estate, but it is possible to invest in IRA in an annuity contract. And there's a lot of life insurance companies who have products that allow you to invest the IRA in an annuity product and that will guarantee you minimum withdrawal rights. And I disfavor those investments. They can be very expensive. They will generate a very large commission for the salesperson, and clients usually don't understand them. Clients usually think that the guarantee of withdrawals will give them a fixed rate of interest on their principal, and they don't do that. And they tell you, oh, it'll grow at least by 6% a year, and then you can retire and get a guaranteed payment. Well, what they don't mention is that when you actually retire and convert this to a guaranteed payment, it may be a 2% rate of return assumption, and they're giving you back your own money. So by the time you die, if things haven't gone well in the contract, your children receive nothing. So enough of that. I find a lot of people come to us and the purpose for a variable annuity usually is tax deferral and creditor protection. Well, the IRA is already giving you tax deferral, and the IRA is already giving you creditor protection in most states. So even in the state of confusion, you get creditor protection. So the next slide just gives you a blow up of level 1. Then we have a blow up of level 2, blow up of level 3, blow up of level 4, blow up of level 5. And Brandon, what would you like to cover next?
Yeah, so I think these are basically, we tried to outline all the possible beneficiaries of the IRA and what would apply if it was them individually taking the IRA, if it was them in a conduit trust, the individual in an accumulation trust, or something that didn't qualify as a see-through trust. So before we go through this, what's the difference between a conduit and an accumulation trust? Well, a conduit trust, and these are special types of trusts that are defined under these new proposed regulations in terms that have historically been used, but the IRS is now formally recognizing them for us, which is a nice part of the proposed regs. Conduit trust essentially says that if something is distributed from the IRA into this trust, it's automatically distributed from the trust out to the beneficiary of the trust. So it acts as a conduit for IRA distributions. An accumulation trust says the IRA paid to this trust, then the trustee can accumulate those assets, retain them in the trust. They have the discretion to distribute them, but they don't necessarily have to. So there's different payout rules that would apply here, depending on those particular situations. So situation one, surviving spouse rolls over. That has to be the individual beneficiary to be able to roll that over. And there are some private letter rulings that a spouse can roll under a conduit trust. So you might be able to rely and get an administrator to roll it over using those private letter rulings, or you might have to actually go get a private letter ruling before the plan administrator would allow that to happen, but that is possible. If it's left under the accumulation trust, then you cannot roll over the IRA. It has to be held in that trust. And then if you don't comply with the right requirements in drafting the trust, you're stuck with this default rule of the 5-year rule or over the life expectancy of the deceased plan owner. Generally, it's going to be left outright to the spouse. The spouse can take requirement of distributions just as if they owned the IRA, using that dual life expectancy that we talked about earlier. We have an inherited IRA for the surviving spouse. So the spouse inherits the IRA, takes as a beneficiary directly. There's certain advantages there. There's the ability to defer distributions until the spouse is 72 under that scenario, or and then you have a little bit of a more favorable payout rule than if it was a typical adult child versus a spouse. What happens if we pay to a trust for the spouse that's a conduit trust? Well, it's the same as if they inherited the IRA directly. The more favorable payout rules would apply. If we have an accumulation trust, this is where we get into the difference. So under an accumulation trust, because we have to consider who inherits the IRA or who would become a beneficiary of the trust after the death of the surviving spouse, and it's not just held for the spouse, we don't get the more favorable payout rule. So that's going to have to come out within 10 years in that scenario, if it's left to a trust that can be accumulated and not distributed outright to the spouse, or at least distributions from the IRA. Now, there are certain exceptions to that. To get into a little bit more detail, trying not to muddy the water too much, but if you have a beneficiary of that IRA or the trust that's the spouse and also another eligible designated beneficiary, so a minor, someone that's not more than 10 years younger than the plan owner, then you can still use the life expectancy rule, but those have to be the only beneficiaries of the accumulation trust. If you have an adult child that's a beneficiary, then you're stuck with the 10-year rule. What happens when you have a minor child? Then you have, if it's outright to that minor child, then there's no distributions required until 10 years after the minor reaches the age of majority. So 21 is now the majority under the proposed regs, so no distributions until they turn 31. And then when they're 31, everything has to come out of that IRA. If it's a conduit trust, then the same situation applies. You can defer until 10 years after they reach the age of majority. And then the accumulation trust, it works the same way as I talked about for the spouse. If you have only eligible designated beneficiaries, so if it's only minor children in there, then you can take it 10 years after the oldest minor child gets to the age of majority. So when that oldest person turns 31, everything would come out of the IRA into the trust. And then the trustee can determine when and if to distribute the assets. If you have a minor child and then an adult child, it's not going to apply. You get the 10-year rule that would apply in that situation. Another situation here, beneficiary that's no more than 10 years younger. So if I'm 75 and I leave it to my brother who's 70, then you have an eligible designated beneficiary where you get the life expectancy payout under individual IRA or a conduit trust, 10-year rule under the accumulation trust where everything comes out within 10 years after death. Adult beneficiaries, it's relatively easy. 10-year rule applies in that situation under all these scenarios. And then the final scenario is we have the disabled or chronically ill beneficiary, and that's one of the eligible designated beneficiaries for life expectancy payouts. So you get the life expectancy payout if they inherit outright. Under a conduit trust, you also get the life expectancy payout, but the accumulation trust, unless you have a spouse that's the beneficiary, or a minor child, and those are the sole beneficiaries, you have the 10-year rule that would apply versus the life expectancy rule for that situation. All right, where do you want to go next, Alan? Do you want to talk, do you want to try to close out, or we want to talk about another topic before we end here?
Well, if we can talk about the power of appointment, I think that's, really interesting for the flexibility we're going to get after these rules pass. So for those of you viewers who want to hear something technical, we'll give you something technical now. And I'll introduce the topic, and then Brandon can give the technical background since I don't remember it. So a power of appointment is a power that you can give a person over a trust to direct how the trust assets will pass. And a lifetime power of appointment can be exercised anytime, and a testamentary power of appointment can only be exercised at death. So I could leave assets in a trust for my wife, Marcia, and I could leave my IRA into a trust for my wife, Marcia, and that trust could be for my wife, Marcia, and our descendants, and Marcia can have the power to make her brothers beneficiaries of that trust instead of our children, as long as she and her brothers are living. So what that would do is, if I die and Marcia and our children are the beneficiaries, since our children are all adults, or at least they're above adult age, then the 10-year rule is going to apply. But if Marcia causes her and her brothers, who are both less than 10 years younger than me, to be the beneficiaries, then the lifetime payout rule can apply. And then when she gets angry with her brothers, which happens pretty often, by the way, then she can exercise her power of appointment again to eliminate them and bring the children back in which case then the distribution would have to be come out earlier. Now, this is under the proposed regulations, so if people die before the final regulations are issued, that will work. We're not sure if the final regulations are going to be as generous, but I would say there's a 98% chance they will be. So Brandon, that's what I remember about powers of appointment. Why don't you now correct me if I was wrong and talk a little bit about them?
Yeah, so there is basically this concept of who do we have to consider as a beneficiary of the trust for purposes of applying the payout rules. And there's it's called the designation date, which is September 30th after the year following death. And that's where we take a snapshot at that date. Who are all the possible beneficiaries of this trust? So, when you have a trust that clearly says, my spouse is the beneficiary, or it goes outright to my spouse, that makes it very clear who's the beneficiary. But what about when you have this power of appointment, as Alan mentioned, that can be exercised in favor of anyone in the world, if you want to draft it as liberal as that? Is it anyone in the world that's now a beneficiary of the trust because I could possibly exercise it in their favor? And how do these rules work? And it was very unclear before the proposed regs came and gave us guidelines now for who you have to consider. So it all is important whether the action occurs before September 30th or after September 30th. So to change things, you want to make sure that you do these items or exercise the power or limit the power before that September 30th date. Otherwise, they're not going to be effective. So if you eliminate the power of appointment, trust protector action just says, we're taking the power of appointment away from the spouse, then the regs say, fine, it's as if the power never existed. You look at who inherits after the current beneficiary. If it's limited in exercise, so you limit it, so it's say, you know, it's exercisable in favor of my descendants. You then limit the power to say it's only exercisable in favor of my brother who's not more than 10 years younger than me. Well, the proposed regs say your brother who's not more than 10 years younger is then considered to be the only beneficiary, and therefore you might have a more favorable payout rule because now you have a spouse and someone who's not more than 10 years younger as the only beneficiaries of the trust, which gives you the life expectancy payout. So in that scenario, the interesting part is if the power is not exercised, then it goes, say, to my children in equal shares. According to the proposed regs, you can just disregard the fact that the children are takers in default, and the only people that matters is the current beneficiary or the power holder and who it can be exercised in favor of since it was limited. We're not entirely sure how they got there and why the takers in default are disregarded, and so it'll be interesting to see what the final regs say on this. But at least as far as our understanding of the proposed regulations go, is those takers in default of exercise are going to be disregarded. Same thing applies if you limit it in favor of two or more possible beneficiaries. So if I have two brothers, or if I just limited to say it's only exercisable in favor of individuals not more than 10 years younger than myself, then you can have the more favorable payout rules apply. What if you exercise the power? So Alan's wife Marcia exercises the power in favor of their granddaughter. Well, then it's the person who is exercised in favor of is now considered to be the beneficiary and the only beneficiary of the trust. The takers in default are again disregarded. And I think in that situation it makes sense, since now that's who the power in the trust is actually going to benefit. If you don't exercise the power by the designation date, so you do nothing before September 30th, then only the takers in default are considered the beneficiaries. So I think this gives us a nice, interesting planning wrinkle. Is historically we were unable to provide for charities under these types of trust, even under a power of appointment, because we were afraid that now we would have someone who's not an individual as a beneficiary, which is one of the requirements of a see-through trust, to get these more favorable payout rules apply. And if you had a charity in there, then you'd be stuck with the 5-year rule. Well, now we can have that power exercisable in favor of charity. As long as we don't exercise it before the designation date, the takers in default are considered the beneficiaries, who are my adult children, and we have the more favorable rule that would apply. But if we do exercise it in favor of charity, then we would have to adjust at that time, but only at that time. So we could apply the more favorable payout rules until the power is exercised, and then the IRA would need to be liquidated at that point. But it would be going to the charity anyway, so there'd be no adverse tax consequences. So this was a nice change to provide a lot of clarity on the use and ability to kind of open up powers of appointment more, or limit them in particular ways to maximize payout rules. I think this was probably one of the more interesting points of the proposed regulations.
Yeah, I think the only thing I think we can close with is something that's just as flexible is, as Brandon mentioned, you can have your trust agreement or will designate that there will be what we call a trust protector who can change things around. Mm-hmm. And the regulations basically say, well, if you change stuff around after death, as long as it's all the right situation on the September 30 of the calendar year following the IRA owner's date of death, it'll all be fine. So for example, if you want the 10-year stretch, you can't have a charity as a permissible beneficiary. So the trust protector gets the money to the charity before September 30 and then moves them out from being a discretionary beneficiary. Or the trust protector moves the kids out and moves the brother-in-law in. So there's going to be all that flexibility. For now, we need to urge clients to have trust protectors. We have 2 levels of trust protectors in our documents. First, there's trust protectors who can change anything anywhere. And then we have the IRA trust protectors who can just change any trust that would receive an IRA or pension benefit to enhance stretch planning, because we call these the stretch trust. So Brandon, I think we covered everything that we wanted to cover. If we wanted to cover everything that a lawyer or CPA should know, we would need about 2 days. We would need about 10 days to prepare. But any final words or words of wisdom here for those of us about to embark upon the rest of Saturday?
Yeah, I think just one point too that I wanted to mention is the proposed regs now allow us to disregard contingent remainder beneficiaries as well. So that's another way you can now use some charities that you historically have not been able to. If there's 2 people in line that would inherit before you, so if you leave it to a spouse, if my spouse dies, it goes to my kids. My kids aren't there, it goes to charity. Historically, that would have violated the non-individual rules, but the proposed regs say we can now disregard the charity because they're a 3rd-tier beneficiary. So that's another important change that you can use in drafting as far as providing for charity or providing for those remote contingent beneficiaries. They don't necessarily matter as much anymore as far as the payout rules go. And then the other thing I think just don't just automatically assume you should let the IRA sit there. There's things you can do with the IRA. You consider Roth conversions, you consider liquidating it, particularly if you have estate taxable clients. Run the numbers, see what the payouts are, see what it would matter if you took it out early. All these things you can do with spreadsheets, and don't just assume always, run the numbers and look at the scenario for your clients.
Oh, and by the way, you could, if you're over 70 and a half, you can transfer up to $100,000 a year from your IRA to a charitable organization, which is can be a very tax efficient way to handle your IRA and get the recognition and the enjoyment that comes with making a large charitable donation. So I hope you'll join us next Saturday, having fun with Dick and Jane, understanding basic will, trust, premarital agreement, LLC, and other items. Please check out our YouTube channel, watch these YouTube videos, and let us know any questions, comments, or suggestions you have, or ideas for presentations. We really enjoy presenting. We learn a lot from presenting. We escape our families by presenting. So we're glad to do it. Have a great weekend, a great 4th of July. Please be safe in all ways. Thank you.